Wait, please, Lordship. I beg to mention item number 12, Lordship. Lordship, agenda matter for the day, Lordship.
Why?
Lordship, conducting council A.M. Ahmed is unable to present today due to his personal problem, Lordship. A.M. Ahmed. A.M. Ahmed, conducting council. Item 12, yes, Lordship.
Then it's talking for the matter
Any date, Lordship.
after the date.
Master, please.
Lordship, item number 9 and 10, can it be taken up on some other day? Maybe tomorrow or day after? Or taken the consent? Tomorrow or day after? Today I have some difficulty, man.
Then the matter. For adjournment made by Ms. Deidre, this is the matter. After the date.
Lordship, I'm seeking a passover for a day in respect of item number 11. As the conducting council is out of station. The 11 item.
Yeah.
It's in advance.
Ishidas.
And there will be no matters otherwise. On the prayer for adjournment, oh, yes, yes.
No, I was handling this 11.
On the prayer for adjournment made on behalf of Mr.
Bibarwa.
B. Barwa, counsel for the appellant. This is the matter after the date.
After vacation.
When, huh?
Lordship, kindly, matter may be taken up on Thursday. It's very urgent.
Why? We come, we have got other matters to do also.
Only
Is there any eyewitness?
No, I.
No eyewitness. After vacation.
May I
Yes.
please the lordship, my lord, this paper book is collected, my lord, so this matter may be listed for hearing, my lord, with the IA, my lord, in the month of January last week.
We'll dispose of the IA, what is that?
My lord, IA and criminal appeal both may be together,
Why?
my lord.
Why?
My lord, it will be convenient for the parties, my lord,
Okay, right.
with the LCR.
Adjournment made by Ms.
Objection filed.
Ms.
Also.
B.R.A. Sultana, who submits that she has received a copy of the paper book. List the matter for final hearing
Yes, my lord.
on,
On
give a date,
January in the convenient date,
end of January.
2019, must have been.
You just right. Office note indicates that respondent number 2 has been served notice.
My lord, similar prayer, my lord, this paper book is collected, my lord.
Madam, okay. Huh?
For hearing.
For final hearing, my,
Legal aid counsel,
yes, my lord.
and you are asking for time.
My lord, hearing for
No,
the,
no, I understand, but then there is IA also.
my lord, IA and what I with one LCR, my lord, IA and criminal appeal may be heard, my lord.
No,
For final
we are a
hearing.
legal
Final hearing, my,
counsel.
final hearing, my lord.
Then what's the point of hearing what is, if you are going to hear the final appeal,
Yes, my lord.
what is the requirement of the hearing a IA?
Close. I can withdraw করবো পারে।
No, my lord, I want to heard the matter, grounds are similar, my lord, what in IA and the criminal appeal, my lord.
What is your name, madam? B.R.A. Sultana.
এখন প্রশ্ন করব।
Objection is already filed, my lord.
That is why we'll hear it.
আজই করানো হলো।
Yes, my lord.
You are a legal aid counsel. You are taking an adjournment on IA. In IA, which has been filed on behalf of for the filing of the sentence.
It is under section 302 IPC, my lord. My lord, in this case, if your lordship going through the IA, my lord, IA is filed for the suspension of this sentence, my lord.
Correct. So,
And there are several grounds, my lord, that are also enclosed in the main appeal, my lord. In this appeal, there is no any eyewitness, my lord.
so,
PW1, who lost the Azahar, my lord, Urmila Govind, she is the sister of the victim, victim deceased. And she lost the prosecution case, and she has no any visual knowledge about the commitment of the offense committed by her brother-in-law, that is the accused appellant petitioner, my lord. First is the ground for asking bail and the suspension of this sentence, my lord. And second witness, Dr. Vikas Sharma, in his cross-examination, he confessed that the injury of the disease may be caused by falling or collusion with hard substance. Besides, he has not found the injury in the human figure sketch.
what is the evidence against the accused?
I didn't find. Only in 313 he said that it may, because the victim consumed liquor due to fall, she sustained injury. And as per the postmortem report, death was due to coma as a result of head injuries sustained as described. All the injuries are antemortem in nature and caused by blunt force, but lordship, on looking into the postmortem report, I don't find any. On what basis this report is given, your lordship? I didn't find any
So
material.
what is the basis for conviction?
Or let us see the judgment, my lord. Lordship, para 21. I have carefully gone through the evidence of the prosecution witnesses, also heard the arguments of both the sides and Lang. Here in this case, there is no eyewitness to the occurrence. The date of the wife of the deceased is an undisputed fact. The postmortem report reveals that there was diffuse contusion seen all over the scalp, with fracture of frontal bone with ruptured underlying membrane. It further reveals that the subdural subarachnoid hemorrhage involving both cerebral hemispheres are seen in brain, with four ventriculars filled with blood. The MO has opined that the injuries were caused by blunt force.
No, that's what she's asking the gentleman. That's what there's, where is the evidence against this? And you're asking for a judgment.
My lord.
Lordship, only one, the garden chowkidar informed, the informant.
Where is,
He is not, I didn't, garden chowkidar
Oh, he's
person
not-
exhibit area, examine.
there's no evidence at all.
It's not there.
Garden chowkidar.
Devojit Tappo.
Debojit. Let us see the evidence of garden chowkidar. 16.
My lord, in this case, also PW3, Niharika Tappo, she admitted in cross-examination that she was not present on the day of incident and hence she cannot say anything about the incident. She also admitted that her deceased mother used to consume alcohol and her father, appellant petitioner, never scolded or apologized. My lord, if PW3 Niharika Tappo is the daughter of the victim disease. And victim disease and the daughter of the accused appellant petitioner, my lord. She admitted that her deceased mother used to consume alcohol and her father, appellant petitioner, never scolded or assaulted them, my lord. She is the main witness, my lord, child witness, and she admitted the actual fact, my lord. And PW4 Devojit Tappo, in examination.
Lordship, one observation of the learned trial court, page 35. However, it appears that none of the witnesses have seen the incident. However, it appears that on the day of the incident, the accused is present with the deceased being his wife. he being the husband of the deceased must be well aware about the cause of death of the deceased.
From where does she say that? From where does the court say that? On what basis?
Further, my lord, but the postmortem report doesn't reveal any evidence to substantiate the fact that the deceased being died under influence of liquor. No alcoholic smell or substance is found on postmortem.
You cannot do only on the basis of examination of the question. Yes. You know, but you can- You make- This probably is down for the performance, but it only justify the fact that we have made for I would dispose it at the. There is no
Answer.
case.
Lordship, let us see whether anyone said that petitioner, appellant was present at the place of occurrence.
Please look.
My lord, other witness, PW4 Devojit Toppo, he admitted in examination chief that disease died due to pressure stroke. He did not notice the dead body. And PW5 Tulsi Tati also admitted cross-examination that he could not see and do not know nothing about the incident. My lord, there is no any eyewitness, my lord. And the accused has not pleaded any guilty. PW6 IO Sri Khogan Bora, he stated in cross that he did not find any blood spot and any weapon at the place of occurrence.
PW, the IO.
IO PW6 Khogan Bora. PW6.
One statement of
Body
the
was covered with a cloth.
lordship. One statement of IO, although it's not admissible. My lord, accused confessed he assaulted, that not admissible. The accused also stated before me that the deceased was taken to the Garden Hospital by him in injured condition, but as no doctor was available at the hospital, he returned the injured and kept her at his. But one of the witnesses deposed, she went to a marriage party and consumed alcohol.
That's what.
Hmm.
And his 313.
Yes, yes,
You see, he's probabilizing.
yes, my lord.
Standard of proving
My
is
lord.
probabilizing.
Lordship, leave it to lordship.
There's no case.
And finally, maybe disposed of it.
Huh?
Finally.
This is the fair appeal. There's no case.
Hmm.
Heard. Though we have not heard you, we say heard. Heard Miss B.R.A. Sultana, learned legally counsel for the appellate. Also heard Miss B. Buya, learned senior counsel as well as learned additional PP for the state of Assam. The present appeal has been filed against the impugned judgment dated 6/9/2024, passed by the session judge bracket FTC H2 H2 T6 in sessions case number 135 bracket capital T of 2023, by which the appellant has been convicted under section 302 IPC and sentenced to undergo rigorous imprisonment for life with a fine of rupees 10,000, in default, simple imprisonment for 6 months, for having murdered his wife. The prosecution case in brief
9 Nikki.
is that
9.
the
9 of 9 Nikki.
is that
9 of 7.
Inspector Jyotish Goyari. Bracket. Okay, he's not a witness. It's again. Jyotish Goyari, Goyari, Inspector, Officer in Charge, Dumduma Police Station, Tindurke, had submitted an FIR dated 5/6/2023.
Shall I take a lead for a second?
So they have that. At around 8 AM on 5/6/2023, he heard that his elder sister, Juliana Gobin had died. Pusta. On reaching his elder sister's house, he found the dead body of his elder sister and also noticed injuries on different parts of her body. Pusta. When he asked his brother-in-law, that is the appellant, the appellant stated that he had beaten up the deceased with his hands and sticks, and upon bringing her home, she had died. Pursuant to the FIR, Dumduma PS case number 15/23 under section 302 IPC was registered. Full stop. Next paragraph. After investigation was conducted, was completed, the investigating officer PW6 submitted the charge sheet under section 302 IPC on finding a prima facie case of murder against the appellant. The learned trial court thereafter framed charge under section 302 IPC, to which the appellant pleaded not guilty and claimed to be fact. The learned trial court thereafter examined 6 prosecution witnesses, and after examining the appellant under section 313 CRP, the learned trial court came to a finding that in view of the investigating officer having stated that the appellant was present with the deceased and the appellant having taken the deceased to a hospital after he had assaulted her with the branch of a tea tree. And as the appellant had stated that, as stated in his examination under section 313 CRPC, that his wife died due to a fall under the influence of liquor, the same proves that the appellant had assaulted his deceased wife, his wife, who died due to the assault. Next. The learned trial court, no, continue, the learned trial court thereafter convicted the appellant and sentenced him under section 305. The learned counsel for the appellant, no, the learned legal aid counsel for the appellant submitted that there is no evidence adduced to prove that the appellant had murdered his wife. As such, the deceased, the appellant should be acquitted of the charge under section 305. Next part. On the other hand, the learned APP, what does she submit?
Chief, I was going to other, so
Hey, leave it blank, so we'll ask her again what she submitted.
there is a
313.
313 and one witnesses have said, Lordship.
That is the police. Okay, right. On the other hand, the learned APP submits that the evidence of the investigating officer, bracket PWC, is to the effect that the appellant had confessed to PWC that he had assaulted his wife, bracket deceased, with the branch of a tree and had taken his wife to the hospital. Further, full stop. Further, the appellant had in his examination under section 313 CRPC stated that his wife had fallen under the influence of alcohol. Full stop. When the evidence of PWC is juxtaposed with the explanation given by appellant in his statement under section 3, in his examination under section 313 CRPC, that his wife had died due to a fall under the influence of liquor. The same proved the involvement of the appellant in the death of his wife. Inasmuch as the presence of the appellant at the time of death of the deceased had been proven. Thus, in the absence of any explanation given by the appellant with regard to how his wife had died, as required under section 106 of the Evidence Act, the non-explanation of the cause of death of his wife was another link in the circumstantial evidence pointing to the hypothesis that the appellant was the only person who could have killed his wife. Full stop. We have heard the learned counsel for the panel. The evidence of the witnesses have been gone into by us, and in none of the witnesses' evidence, in none of the testimonies of the witness number 1 to 5, do we see any connection being made between the appellant and the death of his deceased wife. Except to prove the fact that the appellant was the husband of the deceased. The only evidence that points the finger of blame in the death of the deceased has been made by the investigating officer, bracket PW6, who states that during investigation, comma, the accused stated that he went to the special line. You take it, you take it with inverted commas, okay? Page 20. During interrogation, the accused said so. He assaulted his wife, as a result of which she died. Okay, this part, page 20, inverted commas. Okay? In pencil, and this portion also. Next para. Section 25. Give me the Evidence Act. Of the Evidence Act provides that no confession made to a police officer, comma, shall be proved as against a person accused of any offense. Thus, any alleged confessional statement made by an accused before the police is admissible in evidence and cannot be made the basis for any conviction by the trial court. The above being said, we have also noticed that the learned trial court had also taken into consideration the explanation given by the appellant in his examination under section 313 CRPC that his wife died by falling under the influence of the wife died by falling under the influence of liquor. Huh? You just cited that. Take the entire thing, actually page 24, in invert commas, okay? Next. The cross-examination of PW3 comma, who is the daughter of the appellant and the deceased is to the effect that her mother used to take alcohol. On the day of the incident, comma, her parents had gone to a nearby marriage function and at the marriage function, her mother consumed alcohol. Full stop. Her father never scolded or assaulted her. Though she has stated in her examination in chief that some person had told her that her mother had been killed by the appellant. No such evidence to that effect has been made by any of the prosecution witnesses. The next paragraph, the evidence of PW thirteen. The evidence of PW two, who is the medical and health officer in Tukia Civil Hospital, is to the effect that on 6/6/2023, he conducted post-mortem examination on the deceased at around 3 p.m. His examination, the result of his examination, as stated by him, was as follows. Page 12 from here to yeah, okay. Page 12. In his cross-examination, PW2 stated that the injury number 1 and 2 may be caused by falling or
Collusion.
collision.
Collusion.
Collision. No, collision. Collision. COLLI. Okay. With hard substance. Next one. I think that's all. What is there? What is there to discuss? Okay. The evidence that has been adduced from there is nothing stated by any of the prosecuting witness, except for PW6, that the appellant had anything to do with the death of the deceased. In fact, the evidence of PW2 and 6 appears to corroborate the explanation given by the appellant that his wife had died due to a fall under the influence of. We have no reason to doubt the said explanation given by the appellant. Full stop. As the same is a plausible reason for the death of the deceased. Full stop. Even if we are to assume that, even if there is another view, even if we are to assume the other view, even if there is another view to the effect that the appellant had not given a true account of what had happened to his wife and had somehow been involved in murdering his wife, it is settled law that when two views are possible, the views in favor of the appellant would have to be accepted by the court. For the reasons stated above, we are not inclined to accept the impugned judgment passed by the learned trial court as the basis for the said judgment is clearly hit by section 25 of the Evidence Act. For the reasons stated above, the impugned judgment dated so and so, passed by so and so, hereby set aside. The appellant is accordingly acquitted of the charge framed against him under section 302 IPC. The respondents are directed to release the appellant from judicial custody immediately. Send back the appeal is accordingly allowed. Send back the TCR in appreciation of the, just say that the fee of the legal aid counsel shall be given by the SALSA as per norms.
Lordship, one,
My lord,
The IA, right, in view of the decision made in the main appeal, the IA is also disposed of accordingly.
Lordship, in the, excellent. The postmortem report, my lord. A female dead body around 40 years in decomposed state, hefty build, wearing so-and-so black blouse with blistering and peeling of skin at places, with bloating of face and abdomen, lips swollen and averted, black eyes, rigor mortis past, diffuse contusion seen all over the scalp. So that medical, lordship, I leave it to your lordship, that medical evidence tallies with this one, but evidence of medical says like, subdural so-and-so hemorrhage involve both cerebral hemisphere. If it falls, if she falls, it may not be so much of that maybe.
We don't
I'll
know.
leave it to your
We
lordship's
don't.
discretion.
You see, those are all hypotheses.
Yes, ma'am.
We don't,
Suggestive in nature.
yes.
mass of blood. Nothing.
That- if that- that is the police who are- who go to the FIR. He is the police and this officer, no other disease, that's what he would say. Ah.
January, second half of November.
Lordship, in these cases, your lordship, paper book is ready, although your lordship IA is there. Probably your lordship may fix the matter for final
Yes,
hearing.
ma'am.
Since paper book, and it is not probably a case for bail, your lordship. It is not probably a case
So
for
we'll
bail,
dismiss the IA.
lords. And they,
But in item number 4, the copy is not served upon us
Here for whom?
from victim.
Victim.
Yes, please.
I didn't copy the nine.
Is there a copy?
No, he is not pressing the eye.
IA to is not, IA to we dismissing. In the,
Paper book copy paisa. Same way.
the one for.
Same এটাই, এখনই হোক।
হেৰি ন বিকি চৰকাৰ বিকি চৰকাৰ এইটো বিকি চৰকাৰ policy impair. What are cases?
তুমি কি করবে? IA to?
What three four
Lordship,
zero?
we are not pressing it, your lords. IA, we are
This
not.
340 and 332 is from the same judgment.
Same
Yes, my lord.
So what is the, there is some paper book there also. What is that? Just take out, there's a paper, but the,
আরে একটু কথা আমার এটা শুনুন।
তলত কিবা আছে নেকি IA টোৰ তলত?
Okay, right.
এইটোত নাই ন?
okay, right. And in item, in that, so in 340, everyone has got the paper book, correct?
Lords,
No, just a minute, in the paper. Yeah,
40.
340, everyone's got the paper book.
I got paper book paper it would cover.
same paper.
340 will cover, so everyone. got.
Everyone will be covered.
Okay, right.
Paisa
In the main case, you right?
349.
Mister, yes, Mister, what is your name?
AK Hajong, Lords.
AK
Hajong.
Hazong.
Ajong. learned counsel for the victim. Huh?
Yes.
Is submits that he has not been given a copy of the paper book. Registry to furnish a copy of the paper book to Mr. A.J. Hajong. Next, in the IA 971 of 2024, you're right. Mr. S. Bhattakur, learned counsel for the applicant, submits that in view of the fact that the paper book is ready and the matter can be heard for final disposal, he does not wish to press the IA. To stop. Ms. B. Buyan, APP appears for the state, while Mr. A.K. Hajong appears for the victim. On considering the prayer of the applicant's counsel, the application is dismissed as not pressed.
Lords.
Then, item 4 also same. Item 3 and 4, huh? Acha,
2,
okay. Wait, huh? There is, what about this, 987?
what 9
In 987, Ajong also same. Same. 987, 971. Let's see 987, 987. Just let's see. Here's 430. Give me the other one. 971.
987 is for certification.
It is okay. This is okay. Give me the last one, 170. Interim bid. This also we close. Not bad. When do you want?
Lordship on 20th January, Lordship. January,
January.
Lords. Deeply obliged. to you.
Wait, please, your lordship. As per the last order, amicus has been appointed and we have furnished the copy to them, lordship.
Yesterday, I received a copy of the appeal memo, lordship. No paperwork is furnished or IA.
Paper book has been furnished.
No, lordship, only appeal memo is furnished.
Here for the,
Respondent number 2.
Amicus.
Amicus.
you have been given paper book.
Yeah, I have received the.
You have been.
Yeah.
So what is to be done now? Hearing.
Date be fixed.
Let.
By this time, I may be furnished paperwork.
Okay, right, in the main appeal. Mr. S.D. Purkasa, learned amicus curiae for the respondent submit that he has not been furnished a copy of the paper book. Registry to furnish a copy of the paper book to Mr. S.D. Purkasa. This is the matter after the vacation,
For hearing, my lord.
for hearing.
Lordship.
Now, what about the IA?
It should be kept, lordship. Next date may be fixed, lordship. Second half, lordship, 19 or 20, if date permits, lordship.
Obliged.
Right, in the IA, right? Written objection has been filed by the state to the application under section 430 BNF. This is the matter after the.
Lordship, obliged.
May I please your lordship? As per by the order dated 24/10/2025, this honorable court directed the additional public prosecutor to obtain a report from the officer in charge
Yes,
and submitting the report before.
for the respondent number.
Yes, my lord.
Last one, this off.
A Begum, last order.
Petitioner was sent to jail on 18/8/2025.
Notice to informant.
Informant and notice.
Yes, informant.
Lordship, we have sent a notice, Lordship, But we have not received the copy letter.
Okay. Did not receive the information.
Not received.
There's no TCR also, but written objection has been filed.
Not yet. Yes, we are.
Right in the main appeal, you write. CR has not been sent, not been received by the registry. Further, Ms. A. Begum, APP submits that he has not been given any communication by the OC of the Sarthe Bari police station with regard to service of notice upon the respondent number. List the matter after the vacation. Then in the IA, you write,
Any date may be given.
Ms. A. Begum is granted 4 weeks time to file written objection.
Any date may be given.
Give a date.
Morning.
Why should you adjourn the matter?
My senior is out of station, Your Lordship.
Who's your senior?
Piyush Jain, the conducting counsel.
No?
Feel dismissed.
Accordingly, basing on the satisfaction so drawn, we condone the delay of 258 days occasioning in instituting the connected writ appeal. The interlocutor